I can't deny her though. They my bestie. She's my bestie. That's my bestie. Your pair of eyes had me paralyzed. Toxic nigga, but you made me to a better girl. Smoke, but with you on forever, ever. I can watch you all day, girl, like you televised. You think like this nigga, they ain't never lied. I left the bitches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course, it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. Get mad at my bestie, I tried. That's my bestie, my pretty.
I heard she's the one, she's got it going on. That's my pretty eyes, baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty eyes, baby. Yeah, yeah. I heard she's the one, she's got it going on. That's my pretty eyes, baby.
Hey, what's up, everybody? So we're going into the motions hearing for Karen Read. It should be some good stuff going on. The lead investigator was fired for the crap he did in this case. So I will probably go over that during their breaks or whatever. But anyways, so I want to get into it because I am behind. They start at 7 my time, and I'm not getting up that early. I'm just going to be honest. So I need a 1 more hour of beauty sleep before I get up. You know what I mean? But anyway, so I want to get into it. Also, yeah. Thank you for being here. It should be juicy today. I heard of bloggers on front though. Let's see. Come on, show it. Show it. Thank you. Are you going to show it? I don't know what's going on with my computer today. But all right, let me add this to the stage. Let me leave that up for a second. Okay, motion day 2. Let's go. Right where they start out. I think maybe they start right here. This is not me. This is actually the
beginning have a very line of separation between both Miss Reed's case. I have only saw a search warrant that are on the public docket. And so what I know is that Billy and is in the possession of the district attorney's office, and the information is relevant material to Karen Reed's case. The reason why it's important is that the county, but relationship and where information.
Don't ask me why it's glitching this morning, but it's glitching.
Carney. Originally, a third party was used, an intermediary, where.
Hey, cameraman, get your shit together.
Appeared in the public record.
I don't know that. I know that the attorneys are very well aware. Why
Let me ask you this.
So
Just the name of the intermediate here in Trooper Tully's affidavit.
Okay, let me kind of put you up to speed because it's going in and out. So basically, there's a local blogger that in the beginning was the first to expose all this that's going on in this case. He's the one that broke it wide open. And so Karen Read at first did talk to him in the beginning. Do we know that she was saying, hey, go and intimidate these guys and go do this? There was no, they did a grand jury, and during a grand jury, it's the lowest bar ever, to get an indictment. And they seen no witness intimidation on her part, period. She wasn't in cahoots with them, like they're saying. Well, now they're trying to get his phone evidence into the Karen Read trial, and that's not okay. Like, it's his work product, and what she told him in confidence is none of nobody's business. And for them to try to use that when she wasn't indicted on this stuff is pretty poor. They're doing anything and everything to try to get her to get some kind of charge, because they know how corrupt this is. And I mean, anybody who watched the first trial knows how botched this investigation was. They didn't do a full investigation. You had the lead attorney already deeming her guilty before he even did a thorough investigation. They didn't investigate the cop's house that the other cop passed away on the lawn of. They are doing anything and everything to protect these quote unquote witnesses who really seem like suspects because something nefarious is going on. They're protecting the living their own, and not the one that passed away. And it's just real sad because all these other family members, friends, and all that of the decedent believe this crap. They don't see the evidence. They're not listening to the evidence. All they know is that she dropped him off. She should have never dropped him off, and that's what she's guilty of. Whether she's guilty of hitting him with the car, they don't care about that. The only thing they really want to see her fry for is that she left him. She left him there alone. But he's a grown adult. You can't tell a person not to go anywhere when they're an adult. She waited 10 minutes for him. He never came back outside. She was having stomach problems because she does have illnesses. She went back home and started calling him from there. Thought he was cheating on her. She wasn't thinking something was going on until she found him on the front lawn. Then things started clicking in her head. But anyways, okay, I digress. So let's get into this. I'm sorry that it's choppy. It's not my fault. It is court TV.
Either in the substantially itself or in the addendum A.
I would agree with
Article issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports been requested?
reports that have been generated.
Has the underlying data from the two phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions.
Okay.
Oh, it's so
As it
irritating.
relates to consciousness of.
As your Honor is aware, conscience of guilt is a different standard. Is that there was
Okay, consciousness of guilt, if you really want to go there, is the two police officers that got rid of their phones so they didn't have to turn them over. So no evidence would have came in this case from them. Oh, but the FBI kind of uncovered certain things. Now, didn't they? Oh, you guys weren't expecting that, though. right? The one actually, broke protocol and actually used one of the extractor machines just to get out the text messages that he felt was relevant to this case, to point at her, not to point at his own guilt. You got nefarious things going on. You haven't turned over Sallyport video, and yet here you are asking for notes from reporters, all that stuff. Do you know that they're protected by the First Amendment, that all that work product and their sources are to be kept secret? Otherwise, you ruin their career. If they can't feel like they can be trusted, who else is going to trust them? And you don't give a crap, all just for a woman, you to make sure that she's guilty, because you don't want fingers pointing at the household that it happened on. Well, maybe you should blame your freaking detective that did nothing in the case to freaking search, that didn't do a thorough investigation, that helped his buddies out, that helped his second family out, right? Not about getting him real justice or the family real justice, but only to protect their own. Damn shame. And here you are trying to do anything and everything because your case is weak. You got a weak case. When you're doing all this extra shit and you don't just let the facts lie where they may, and you're after a strict a strict conviction and not about the truth like real prosecutors do, and you're not about truth. Let's be honest. You are a mob boss attorney. You know that. You're a defense attorney, dude.
A relationship between Karen Read and Mr. Carney. And Ms. Read would provide information indirectly to Mr. Carney, and consequently, what witnesses in the search warrant itself.
What he posts on social media, he didn't say, hey, everybody, let's go intimidate these guys. He held picket signs out front of people's houses. That's all he did. That's all he did. And you guys call that witness intimidation. All he's ever told them was to tell the truth. I guess telling the truth is intimidating them, huh? That's telling them to retract their story and tell a new one? No, he's just saying, tell the truth. Period. Quit hiding behind the badge and a gun. Quit trying to get your other fellow men in blue in trouble. There's one that had to fall on his sword because he helped others. I hope he rolls.
Extraordinary detail on how Mr. Carney targeted witnesses in Ms. Read's case with the express purpose, according to Mr. Carney, that this trial of Ms. Read never go forward.
Hey, Eva.
We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts, if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the date in question has to make a initial factual showing that it's relevant, not potentially relevant.
Come on, get your cameras together, Court TV.
I'm not clear on your question, Your Honor.
Of course you're not gonna.
You have sought a broad swath of data. We don't know the volume yet, but it is from the Addendum A to Trooper Tully's affidavit in support of the search warrant. Alerts, reminders, notes, text messages. videos from April 1st, 2023 through and including October. 7 months of material that ostensibly could include everything from meeting notes.
Oh my goodness.
Can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Carney, so.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Counsel, can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of the Court. We didn't see which case number was called for this Rule 17, if it was Mr. Carney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Canoni, was if this issue is going to be dealing with is on Ms. Reed's case number as it pertains to her rights. And the
This
issue
meeting is being recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular.
the case number that was called was the Commonwealth versus Karen.
Brennan
Zero,
didn't
zero,
like
117.
that.
Okay.
That's correct.
Let's go. Oh, you got ambushed there, Brennan. Oh,
Forward in terms of her case. This is her case.
She have to challenge a Rule 17 request to documents produced in another case.
Because it specifically pertains to the prosecutor asking for information.
Those are evidentiary issues, counsel,
Correct, but we...
which can later time. Those are what you're suggesting are evident. For Mr. Kearney's case, the evidentiary issue will be dealt with at a later time.
I
This is
understand, and respectfully, I don't necessarily be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth has, there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. Rule 17s dealing with third-party information, cell phones or text messages or whatever. I think that he'd be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
counsel, this motion's been pending for a week and a half now. I don't have opposition from you. I don't have any submission from you.
We intended to submit oral argument as it is, and we're prepared.
And did you give the court notice of that?
We did to Justice Canoni.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Mrs. Little is prepared to address the court on the very issues Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current?
He didn't know he was going to get ambushed like that. I
step
can
back,
trust
I will-
him.
Mouse in the room. I just need to be.
Oh, these camera issues are going to piss me off, though.
Mr. Brennan is finished. I think we have we should be good.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my filing, if that's an issue in terms of a filing. So just put it
Thank
down.
you. Thank you,
Well, you're
Chairman.
right, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion to rules. Not a party on the Rule 17.
Thank you, A.D. Brennan. Case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her A.D. Brennan, with the court's apologies for the interruptions. The crux of the issue, I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant.
All these camera issues. Get your shit together.
Materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree. A far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at in the murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert,
Because they're too
including
busy
but not limited, would suggest
protecting the ones that might had something to do with
Karen Read case.
the murder of John
B
O'Keefe.
is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence. Clearly on point and relevant to the Cromwell versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information supposed to be captured.
Oh, come on.
Because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is
Categories include
Every time it glitches,
Mr. Kearney with counsel from
weird.
no, I think those would be privileged. Secondly, there are most filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Prosecutor Cosgrove. And in that motion, notes that the two phones that I'm seeking information from have already. And he also notes in the motion that it does not appear to be an attorney-client. Commonwealth's revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable?
Just because she was providing information doesn't mean
Of Mr.
it
Kearney,
wasn't already
which she helped
public.
fuel
Sure.
this information
It's her
and
case.
identifying the witnesses in
It's her case.
because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available, and if the court wants to hear it, I can play it for the court.
I don't think it's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact that this information is pursuant to a warrant of public cause, in light of the proffer and the
Because
affidavit,
I gotta prove everything. Because I know my
its
case.
consequence to witnesses, this is relevant to conscience of the evidentiary basis is clear. I do not have acting out of an abundance of caution to be beyond
Hey,
reproach.
Hood.
If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree.
Oh, you'll go get the information on your own? Hold on.
Not the
Did
entire
I hear
file.
that right? Wait a second, sir. Hold on. I think I heard something. Let me hear that again. Let me hear that again.
And evidentiary is necessary. And again, I filed Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order.
Whoa! Hold on!
Review the materials.
Whoa! Whoa! Hold on. You can't go do that, sir. That is against the law. See what you dirty sons of bitches will do to make sure that you make a case stick, you dirty, rotten son of a bitch. Wow. Oh, I thought I was going to go the legal way because I thought I needed it. But if I don't need it, I'll just go get the information on my own. No, you won't. Kearney, You better put that under lock and seal. You just heard him. He will get that information. They already got that information, by the way. But still, he'll go get it himself. He doesn't need a freaking judge to tell him whether he can use it or not. Wow.
Irrelevant, and I agree. The scope should be limited to D, E, and F, not the entire phone. And those materials will be provided to Judge Cannoni.
Wow.
For both the Commonwealth and for the defense. It's in good faith. I've provided both pleadings from Mr. Carney's case, the search warrant affidavit in support of the warrant.
Oh, wow. Wow. You dirty son of a bitch.
To the relationship.
Go get it on his own. And don't ask me. StreamYards is acting funny.
Good morning. More Empron request is the case.
Let's go, Bradle. Come on.
Warranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour. I happened to look at the Read docket last night. It's how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the meat of the trial. It was a question of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning there has to be evidence.
There's no evidence. You went to a grand jury.
Not otherwise obtainable.
Faces.
You can't prepare for trial without it. And most important, Judge, is that the application's made in good faith and not as a general fact. And Judge, we didn't have a dog in the fight back then. As far as my client and I knew,
I can't believe it. In open court, the prosecutor, the special prosecutor, because he really is a mob freaking defense attorney. Anyways, Mr. I go against corruption and all this other stuff, but here I am. I'm complicit in it all of a sudden, right? Mm-hmm. Okay. Anyways, I cannot believe he just said, well, if I don't need I was trying to go the legal way, but if I don't need the legal way, which you do, this is a court, you need a legal, I'll just go get it myself. What the? Right in front of the judge, and the judge didn't do anything? Like, what? Oh, man. I'm glad I don't live in Massachusetts, because, baby,
we're going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, it was probable cause in a search warrant. And they took it to a grand jury. They had two easy, you can have here. Sit in the judge during the breeze with search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
Not me. When you say you, not me.
Right, not you. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information.
They don't like it.
And I remember when this happened, just sort of, not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution as an attorney, I saw this, I read the search warrant, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it and I looked at it again. The government just wrote a 30-page short story about.
Okay, I don't know what's worse, StreamYard action up or
find and isolate communications.
Where I'm getting the
wants to criminalize communications. And if you look at my press, read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs.
Present all something, I don't know. We're
with anyone she wants and say, hey, keep this between us.
Yes.
That's her right.
Yes.
Her constitutional right
Same with
under
journalists.
the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare opposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. just the
So
notions that they put in the
attorney
search
that,
warrant,
or
and ultimately the fact that they tried to use it to get an indictment.
From here to kingdom come, because she's
Evidentiary value. The relevancy is zero.
been dying to get her
Can't
story
put it
out.
into evidence.
God knows why, but before a trial, she should have kept her mouth shut.
It's my understanding, and everyone's here, and they can correct me if I'm
Every
wrong.
statement she said
The government agreed
against her.
to not put anything in their case in chief relative to this issue about communicating with Mr.
Absolutely
Carney and
ridiculous.
consciousness.
They tried to get it with other people too, and it didn't work. Come on, but you didn't charge them with witness intimidation.
And so
Now
that
did
adds
you?
to the issue of whether this is evidentiary or not. The government's already back off. The government got a search filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, "Hey, person, and let's get them off, and let's try to have that person not testify. Let's scare that person. Let's harass that person." There's no communications like that. They just have the fact of communications, and that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's any motion to dismiss with Judge Doolin basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel. The taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up.
That's a big issue.
With respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17?
All of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them. They're all protected by the. Let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation. And it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge.
Unless you're hiding behind
set the
corruption.
context.
Just saying. Court TV, get your shit together.
That is a landmark case that involves the notion, and the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about it or not.
That's how they hooked us. It's called a tracking device. They don't need to. They gave us cell phones.
Quotes, Your Honor.
Everything's in our cell phone.
Just about everything that is materially important to messages, emails, notes, thoughts, communication, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in.
Just because it's in his case, it doesn't need to belong
ADA
in
Brennan is
ours.
looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials you just rattled off.
the search never
But
should have
that
happened.
issue
It should
isn't
have gone through
before
the
me,
taint.
counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke, and the fact they spoke is it's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd be at the wrong decision in Onyx White, Your Honor. That just because people why I'm here. And the last thing I'll say, Judge, is that the fact that we got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team litigation to be done, the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privilege information. There's a ton of also the taint team to scrutinize the phones for. We're going to ask for husband-wife.
You got to ask him.
Husband-wife communications. We're asking for that journalist source material. There's a plethora. You know, the fact that they did this, the court should deny, Judge, just all about undue delay. They had this back in February. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, A.A. Brennan, before I hear for any further response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little.
Thank you, Your Honor. Elizabeth Little here on behalf of Ms. Reed. First, I just want to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bragel's request in opposition to this rule. Attorney Bradel. Apologies, Your Honor. There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. And so just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. A.A. Brennan, I'll hear from you in response briefly.
I think most importantly, the parties are conflating two issues: whether there is probable cause or beyond a reasonable doubt to convict a person of a conviction of witness, and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there was litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradel. It is this reflective of consciousness of guilt?
Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion, there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
That is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is open, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witness once the door, if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness is something that reflects her consciousness of guilt her for the crimes that she's alleged to have committed. We know she was providing information, even protected information to Mr. Carney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on condition of witness or not, felt very intimidated. We know that because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth versus Karen Read trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes. And my teenage kids
dinner.
Yes, exactly.
Right.
Exactly. So if you want to, reupholstering is really expensive,
Yes,
right?
it is.
So if you
hopefully they get this fixed in time for her court hearing. But yeah, I think it's this case is pretty wild. I watched the first one, and the first trial, and I was done at red Solo cups and leaf blowers. I was done there. And how that morning in 3 inches of snow, they didn't find any taillight pieces that they claim that she, that's how she broke her taillight, was by hitting him 24 miles going backwards in the snow. They didn't find any that morning, but they waited until they confiscated her vehicle, and then all of a sudden they found three or 6 pieces total or some shit. And then 2 weeks later, they kept on finding more and more pieces. This case is so corrupt, and how they're doing a second trial, I'll never know. But I mean, she's put $5 million. I mean, this is like a $5 million defense for the both trials. So it's pretty crazy. And I mean, thank goodness she's got the money to do it. But what if it was a regular person, like a poor person like me, that can't afford $1 million defense? What, they just throw the book at you? I think all attorneys should fight for their clients like they're $1 million attorney. That's just my opinion. But whatever. Okay, hold on. Let me get this going because I'm not trying to sit here and wait. Come on. Short break in my butt. Okay, we're coming up. Right about there. Okay. And we're in fast mode because we're playing catch up. But yeah. Okay, why is there no sound?
Karen Read, I have counsel identify themselves to record starting with the Commonwealth.
Good morning, Mr. Blanton.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Read.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning. But what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
In other words,
Yes.
he's not going to do it.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're
I understand
defending
that,
all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right. Does the Commonwealth want to be heard on this?
He doesn't want to push it back. We already know.
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different, but most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches, and we'll take it from there, but we will start April 1st with impanelment. Okay. All right. So let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it. I have it here somewhere. I'll find it. So we did hear from people this morning. I know you all have. I have it. I have it, Jim. I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
We received it.
Okay. All right. So I'll hear the Commonwealth on your buffer zone motion.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case.
Well,
The
then
courthouse
tell
is
them
very
not to
close
show an
to
emotion.
the public areas where people congregate.
If they are going to show
Been
emotions,
reported
they need
that
to leave.
during the trial, the
Because that
jury would be able
influences
to
them.
hear outside noise and influences, not
Or
just
not
from
have
horns,
the
but
cops that were
other types of
involved
noise that could be
getting
influential,
over there
intimidating, concerning.
during closing
And so
argument.
we've proposed what I think is reasonable and minimal.
Okay, if you don't want outside influence, all that great stuff that you preach and speak for the sanctity of the jury, then see this? See the mother right here, this grieving mother? Her showing emotion affected them. Then you had the cops that were inside the house that the cop died on their lawn come in that day, and his sister-in-law staring down the jury. That's another influence. So if you want this sanctity of the jury shit, make sure it's all around the board.
Recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence of the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market in my memory from coming by on other cases, at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing or in the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take no position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay. Yes.
Can I just have this mark for identification for this hearing, identification? And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyway.
Hey, Trey.
All right.
Your Honor, can I be heard on that one issue? Just briefly.
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll
Okay.
happily add the town to the court, but I believe they put a footnote on their witness list. I think they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses.
Oh my
which the
gosh.
Commonwealth believes is ongoing.
Stop already.
I think a potential
Stop.
resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interest of the Commonwealth and the witnesses.
You
from-
just want to.
I don't have a problem with that. I still need
city.
cities and towns.
Of course.
Okay.
Yeah.
All right. Thank you. So we will start with paper 593, the Commonwealth's response.
Anything and everything to protect all the people that were in that house when he died on their lawn. All of them. Why you throw her under the bus? Absolutely crazy, man.
Is paper 610, defendant's motion to eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
Sure. Yes.
Defendant's motion.
Commonwealth. that's
I'm
why-
sorry, defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever.
I'm fine with going first if you'd like.
Okay.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons.
Oh my
It would
God.
undermine Rule 403. It would cause a trial within a trial.
But everything you
As
do
we
is
stand here today,
unfair.
the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone.
Yes, we get it. You think that the defense started this whole federal investigation. They have no bearing over what or who the federal government investigates, dummy. You should know that. You are a mob boss freaking defense attorney, dude. You should know that more than anybody, but here you are. Here you are acting like, oh yeah, people can, miraculously call up the FBI and say, hey, my client's being unfairly tried. No, they let the states do their thing. But when they see some thing going on, when it involves police officers, then they kind of, let me go ahead and check this out. When they find nefarious shit going on, that's when they start a full-fledged investigation. The Commonwealth don't like it because it makes them look like assholes. Because the federal government told you not to try this case. They told you not to. But okay.
Before the grand jury, we do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information.
There was an inquiry? When was there an inquiry? There has been no proof of that, sir. Where was the inquiry? Huh? The inquiry was, this was the death of a police officer. Other police officers were involved because it was at his house. That's why I say involved. I'm not placing blame or anything. And when you got a cop that ain't doing his freaking job, they're going to get involved. That's why they got involved in the Sandra Birchmore case. Cops were involved. They covered it up. That's the same thing going on here, sir.
Nation to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is a undefined relationship
You
between
do
the
know.
defense and the United States Attorney's Office around this time.
You
of
know all the
investigation.
materials
And
they
we
got
subsequently
and
learned that
didn't
there's a-
get.
there's a
Hello?
continued relationship. And so to date, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for
They weren't
discovery. We filed
inculpatory,
a defense
whatever,
motion for
sir.
discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there are more communications, there's more interaction. And so
No, you
it would
don't
be,
know. You're just
misleading
assuming.
to have our witnesses get on the stand and then suggest that they were independently hired by the federal government and
They were.
all of their attempts and efforts
They
in the court
were.
was wholly
The
and
defense
entirely
just paid them
effective.
for their time.
Just to give one point that
You could have called
emphasizes
them.
the concern.
No,
The
You
ARPA
wanted to
witnesses were
railroad
never
a
given
woman.
information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA. There was a hair, Mr. O'Keefe's hair. And so we know they didn't have all the inculpatory information. And then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls.
Here we go with more bullshit.
Emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned, as they should well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad
because what the Commonwealth's
playing
under
ground to have them
investigation
get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did in the first trial. They were hired independently. And then subsequent to that, the defense retained them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery.
Oh, shut up.
And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 or 3, as you noted, that vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 or 3 of those witnesses. But more importantly,
They told you exactly what they did.
Because as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else.
A hair, not blood.
Could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think
You act like there was blood all on that tail
I
light.
do not want to be moving
There was
during
no
trial to
blood
exclude
on
the
any
defense
of those
witnesses
pieces
related
of
to
tail
finding
light
seen compliance
or
and
her
My
vehicle
suggestion is
other
to follow
than
protocol
a
for
hair,
trial, but
and
before
they
that,
were
these
living
witnesses should be brought
together.
in so that we can
Get outta
obtain
here.
actual records, not just ask them the questions
Get
and
outta
rely on
here,
their
dude.
word. I think based on their past performances, that's insufficient. I think we should have a right to the
And,
records.
and
to demonstrate
it's
the accusation.
miraculous that that hair stuck on all the way through that drive.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARPA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth.
Right.
In the first trial, this court disallowed the ARPA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So could you answer that now, and then I'll let you say everything.
Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the argument.
I know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered. Nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. I've never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA, and they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Read or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes.
Oh, Lord.
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury's entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have
Because
nothing.
you guys were under
Now,
investigation.
I didn't know that Attorney Yanetti's
you were
file
the
was subpoenaed.
target.
That's new to me. Perhaps the Commonwealth knew. I've never heard that before.
You were the
I don't know how the defense knows what the
target.
federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case.
You
or their investigation. We didn't have any interaction, not because we chose.
Okay, sir, sir, the 3,074 pages of their investigation that they handed over, not only to the defense, but the Commonwealth, you act like you were just left in the dark and you didn't know any of this. But you did, sir. Hello? I just love it. I love how you can just preach some falsities and Canoni doesn't put a hammer to you. That's what I'm surprised about, because you give a lot of falsities. You don't give no facts. And she lets it slide by.
From his couple.
Oh, we weren't invited. They're not invited either. But at the same time, this is a dead officer. And hello, do you not remember? Just yesterday, the lead investigator was fired for what he did, his investigation and how he conducted his investigation and his disgusting texts and all that stuff in this case. And you're playing victim? No, sir. You guys shouldn't be able to get away with this shit.
No. Now, I hear now that Mr. Yanetti's file was subpoenaed and information, whatever it was, as they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there's anything improper about the relationship. I'm not suggesting that, but there was.
Obviously you are because you keep on bringing it up. And, I wish I could go back and find that pretrial hearing, because Jackson stated exactly that email that you're talking about. That whole email. Jackson said it in court. But everybody wants to, glide past that and say, oh, he misrepresented and da-da-da-da-da. No. He was honest all the way up till the check. They weren't honest about the check. Whoops. Because they weren't paying for their testimony. They were paying for their time. And you guys are throwing a fit because you want to throw a spaghetti at the wall, when usually the spaghetti thrown at the wall is usually the defense, not the freaking Commonwealth. This is absolutely crazy. I can't wait for this second trial because, baby, and I swear to you, you know what? Let her get found guilty. I guarantee. Because you say that the federal investigation is over. They ain't gonna. Why would they tell the target of their investigation that it's over? I mean, that it's still going. Why would they do that? Why would they do that? That's dumb. But baby, if she gets convicted, oh boy.
Obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we.
Well, what are we doing?
Them as independent witnesses when there was an agenda and it wasn't in the Commonwealth's interest, obviously. The ability to
Because you were
cross-examine a
trying to
witness is
do them
only
as-
as good
it
as the
doesn't
evidence
take
and
two
information you
fucking
have, as you've seen from the ARCA
brain
witnesses.
cells to think that.
From my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy
You're
guide
just mad because
unless
it
they've
goes
established
against what
the
you're trying to
credibility.
do.
I don't see that in these
Period.
transcripts.
I
Where it is
need
their bias.
materials.
And so simply
It's in the
cross-examining aimlessly is
3,074
totally ineffective. It's a
pages.
recipe for disaster, and that's
You
not the
need
type of
to look
examination we're
through
gonna
those
engage in.
pages,
If we're
sir,
going to
because all
tell the
that
whole truth,
information
it
relies
has to
on
be the
that.
whole truth. And I think that becomes a
Jesus
dangerous game. There'll be an
Christ.
entire days, entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right.
Oh my gosh, again?
We're going to move on. I'll take this under advisement.
Can I just ask the
Again?
parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
This is ridiculous.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge. But
Okay.
during the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that we have a jury sitting for weeks at a time, away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth is, what's the basis for your objection?
To make a record at that point.
I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know.
I agree with that.
And
I should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections, as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly.
To exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right. So that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right. So we can address it later.
Thank you, Your Honor. And for a voir dire, that also part of your consideration?
So if I feel I need to reconsider it, that's the time to do it after
Thank you.
Dr. Russell's testimony. All right, there's a motion. It's 599. Defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion in limine to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion in limine to exclude, pronounce his name, Mr. Brennan. Welcher and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do.
For this motion.
Okay. Mr. How long do you think it'll take?
It's really dependent on what Mr. Alisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11. I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number one, 575. Commonwealth's motion in limine to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes stenographer for prudent practice.
We've already done that.
Okay. Preventing identification. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There's been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. Circumstances of this case, I ask the court to do that.
Any objection from the defense?
In that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors.
Oh, well, if it's sidebar discussions regarding your incomplete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This
change.
is a new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason from hearing legal arguments on the admissibility of evidence, but this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a court would be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right. So I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the one photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms. Little? That's allowed. 578. So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses at a call regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different from questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. For those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for the defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scordi-Bello. Oh,
Not on their witness list.
right.
She's number 81 on the Commonwealth's witness list.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point. They are not likely to call a medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the registry of motor vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick one. So that's paper 580, Jim? Commonwealth's motion to eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer, does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice of the doctor? Your Honor, is the court's question common practice of giving everything or is it common practice of running queries?
It's actually seems to be both.
I believe I've been informed that it is the common practice and that is the practice we would follow to give everything to the defense. I
You
think
haven't
the
given
assumption that
anything to
the
the
Commonwealth would not
defense.
want somebody with a criminal record on the jury might be
Let's be
misplaced.
honest.
Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
Right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But I
giving the
thought-
jurors a
Well,
chance to correct
at
what they
17,
put on the
they're
initial
not,
form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right. So you're asking me to flat out deny the motion, but if I allow it, you'll get the copies.
Correct.
Okay. All right. Why don't we take the morning break at this time and we'll come back
Hold on, I gotta find that.
and we'll do that motion, the defense motion regarding Dr. Welcher.
What the hell happened? Hold on, I
You
gotta find the
unmuted.
charger. This has gotta be charged too. Okay. Had to find the charger before it denied me. Goodness. Okay. Let me fast forward this. Do. Okay. See where we at. 147.
Before we begin, realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure, I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire?
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
Okay, so it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah,
That
understood.
would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes.
Oh, shut up. You just want another piece of the pie.
We have a court.
You already had a voir dire.
That includes the request for this information to show bias, and I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
Now, please speak with Mr. Brennan at your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
May it please the court. In my presentation today, with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation,
Okay.
what the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Dalbert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CDs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Dalbert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that's not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit, comes right and is used in case of cannabis. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140 slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area. In the Dalbert Lanigan analysis, it's referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava..."
So wait, because they know that their medical examiner couldn't determine the cause of death or the manner of death, and all she stated was blunt force trauma. That didn't look like and because it was detrimental to their case, or whatever you want to call it, it was bad for their case. They're calling all these experts instead of calling the medical examiner. That's weird. They're doing anything and everything to try and get a conviction. They don't care about the truth. I mean, if you had truth behind you and facts, you wouldn't need to use all these experts and all this other stuff all of a sudden. You would roll with the punches if you were about truth and facts. All you care about is a conviction. Why? Because you're afraid that if you don't get a conviction, that one of your own is going to go down. Well, guess what? Even if you do get a conviction, I guarantee one of your people are going down. One of your people already did go down. They lost their job yesterday because of how they conducted this case.
Used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused is italics in the opinion, her to suffer from.
And in all honesty, I hope he rolls on every single one of you because he lost his job trying to save your asses. That's sad.
MCS, this was an error. They went on, quote, because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert.
Honestly, okay. I know the F I would. I would. I know the F I would. I definitely would be rolling on every one of you that I tried to save your behind and I lost. And I lost my job because of it. Because I was trying to be a friend. Well, no friend would put me in that situation to begin with. I'd roll on you. Definitely. I'd roll on you. In a heartbeat. You bet your ass I'd roll on you. because no friend, I don't care who you are, no friend, no second family, no nothing, would ask me to risk my livelihood to cover their own butts, whether I lost my job or not. There ain't no way.
Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion. In the concurring opinion of Justice Greene, he added an important point. I quote, further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science. The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Cadavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next
well, and all these people,
case
so
I provide is Commonwealth v. Meeks, and that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence, such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is quote, essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, it is the subject of a slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the deceit. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintolo. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. What the High Court said there is that the precise question is whether Julia Nelly, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintolo was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintola. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or industry materials on this topic. So the court, with that Dr. Welcher and his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giulianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giulianelli's methodology or experience. Instead, it appears that Giulianelli designed these experiments on his own without any guidance. Reading down below, quote, Giulianelli's experiments also did not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giulianelli did not repeat or validate any of his 6 experiments is also significant. There is zero in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied. And when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this case, is where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that, but the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2A Romanettes 3 and 4. Romanet 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe. That's his heading. Karen Read stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Read knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe, or frankly, anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1:1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. It's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony is truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, etc., and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
I wouldn't be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the
Cause of death.
he would not be offering the cause of death? I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. Hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one.
Sure.
Thank you. He says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many data moments. I'm sure your Honor may wish to not remember, but with regard to Mr. Green, etc., we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, arm, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E, I'm sorry. Mr.
Throwing spaghetti.
The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. That's part of the conclusion. So there'll be evidence.
It had just begun to snow.
You can rely on that.
Began to snow. My bad.
The taillight. But frozen ground, we agree. That would not go into Dr. Welcher.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
The air temperature and ground temperature are two different things, sir. The snow was barely starting to accumulate at the time of the incident, supposedly. Sir? This is a bunch of shit. Anyways.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear.
Okay, they're trying to get it in through this supposed expert, whatever, and not the medical examiner that did the autopsy. This is freaking nuts.
Fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie, Nagel, and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, a clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that. What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Read, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34 Fairview. Even more egregious than H, Romanet I. So with regard to Dr. Welcher, I have, again, genuinely tried to assist the court with regard to blue penciling
Because they're
his
only trying to
report
protect their
to
own.
make clear, based upon the case law, what is within his bounds and what is not
True that they
within
took
his
somebody's
bounds,
life,
based
let
upon his
alone,
own stated parameters. And
let's
with
get
regard
on to
to
the
the
issue.
case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment, prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rintala talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the car is in contact with the taillight, we want to produce. The drop test, similar to ARCA's test, we intend to offer that. But as far as the extraneous commentary, that's not intended to be, it's not proper, and we wouldn't try to use it.
Do you intend to use all 140 or however many?
No, we were comprehensive in the production to the defense so they could see the data points.
I can understand the drop test and
So we've included these
the force test, the same thing that ARCA did.
Showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm, and also we would want to show the ways, locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on that?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right. So this will have to be provided to you prior to it's done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I can have them by Monday.
Okay.
And Your Honor, if we have an issue, still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basics.
Sure. So you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond, and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to. And we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are. But I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan.
I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but a case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and
Oh my God!
Walter have
Shut
some
up, you
similarities
whiny
because
bitch.
they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production.
Oh
But
yeah.
Dr.
mhm.
Welcher gave us
Oh,
an
yeah.
entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statements. So, for example, as Attorney Alessi
It shouldn't have even been provided to him, in my opinion.
Witness did not see damage to the taillight. She'll
Because
testify to that
that's-
herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to see the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2-1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes
Julie Nagel,
in the abstract,
not
let alone the
Julie
details of it.
McCabe.
Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for
that's all they
Mr.
said.
Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the
Oh my God, they already testified who did what, sir?
report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the
Because there was broken glass at the seam, dummy.
That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions.
Oh,
and
shut
conclusions.
up.
He shows
It's
and
been
demonstrates them with
protected.
videos and pictures and photographs. Quite unlike ARCA, where it is just simply a
Okay.
conclusion
You're
based
the
on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Lisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses.
That's what
by
I
Dr.
said
Welcher.
too. Is they
These
need to
are
they
his
need to
opinions based on
show
the
their
study, the
work.
evidence, and he goes to the extent of
I
actually
will agree with
demonstrating
Brennan on that.
those different
That's the one
assessments
thing
that
I
he has
wish
made.
ARCA would have done
In
was show their
particular, the
work.
defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused. But if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They
Oh,
both have a
Lord.
different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis.
No, different
And
opinions.
so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know.
No, it doesn't show time and place.
Went from the waterfall to the flagpole.
Sir.
We know where it didn't stop along the way. We know based on the phone data, Mr. O'Keefe's phone data, when he was in the car until we have all that evidence. And as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses.
Oh, I hope.
And it's
I hope
the
they do
location
some
and timing of that
geofencing
car is
stuff.
important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone
I don't know why StreamYards just kicked me out of my own thing. Rude. Rude. Hold on just one moment. StreamYards is acting up. Okay.
Data, his location data, his cell phone battery temperature, it all coincides. He should be able to consider these things in his study. This is what he does. Demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements, which has been provided, science and data, by the ring videos, which will be independently a smudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other evidence. You can see, doesn't he shows not only the nudging in the video, but analyzes it, and you can see exactly what
my
those two cars came
goodness.
into contact, and it wasn't the
Oh my God. Quit acting up.
nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion
Why isn't that
that the
showing?
lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, it will be presented to the jury.
Oh my gosh, it's not showing. Why is it not showing? This is irritating me.
It shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity
You're driving me crazy.
the height.
I can't do the
and that is based on
the slow touch. Hold on. Stop for a minute. Okay, now we're gonna add this. Hold on. Technical difficulties. I don't know why, but it's really starting to tick me off. Where's my watch list? No, not there. Pause. Oh my gosh. This one. No, I want to watch it now. Escape. Pause. Pause. Okay, hold on. Oh my gosh. I was like an hour and 50 minutes behind. Come on.
demonstrating those different
No, I don't want that. I want this. Thanks.
assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as effective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welch's opinion is different. It's the same engineering, the same science, the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused. But if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time.
No, it
and
doesn't
place
show time and place,
information
sir.
we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone. Within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature, it all coincides. He should be able to consider these things in his study. This is what he does.
Okay.
The demonstration at Meadowbrook, John O'Keefe's house, it's depicted by measurements, which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging in the car leaving through the ring video, but analyzes it. And you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, the location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Lisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. we'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery. Okay. Sure.
Thank you.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it on a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries. I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Daubert factors. So in conclusion, Your Honor, I go back to Rintala, I go back to Meeks, I go back to case of Caravan. The Commonwealth has not today, not before, this is their fourth time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This isn't the first time that Mr. Alesi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered in the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made
Commonwealth, you're not the victim. You're not the victim. Quit playing the victim. The victim is the person that's lying on the lawn that you should be finding out what happened to him. Because getting him justice is not making a woman that probably had nothing to do with it guilty. Real justice is finding out what happened to him. Not conducting all this random BS that you're doing. And stop playing victim. You're not a victim. You're not a victim.
made representations, reckless representations in court that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one.
Well, you did the same thing, dude.
And that is all part of the strategy here. Now, if you look at page 13 and 14 of...
And she'll go with it because she's a biased mother effer. And I just can't believe that she's allowing you to go with this BS.
Dr. Welch's report. Perhaps that was missed in the review. There are resources in that report at number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right, thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations and chalks prior to using?
No objection.
Okay, thank you. 583. Is there an objection to the Commonwealth's motion limine to allow the expert Celebrate demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right. So we're going to have to table this. We may end up coming back tomorrow.
I can do it unless you tell me what.
No, let's see what we can get before the luncheon break. The paper number 585. It's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case.
You don't know his state of mind, dude.
In addition to the charges, this has a
He's
domestic
dead.
aspect to the case. We know from his
Sadly, he
statement
lost his life.
that he was
You
in a
don't know his state
relationship
of
with
mind.
the defendant. We know from the statements that there was a tumult in that relationship, and
The
many of those
relationship
statements
goes
are
through it.
reduced to writing.
Doesn't mean she
The
killed him.
state of mind of Mr. O'Keefe is reflected in
Or
those
the
statements.
state.
There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear based on that and other
But some can hold a bias against her because they feel like it's her fault because she left him. Everybody that sits there and talks about John O'Keefe and how he passed away, they don't say that she hit him. That you don't want to know what their qualm is that she left him there. Plain and simple, that she left him there. And just because they were going through relationship stuff, every relationship goes through it. Ask his brother. His brother's going through it now.
testimony that he was in the course of attempting to end the relationship with Miss Reed.
Two eyes,
And
not
so especially over the course of the day of this incident.
All right. So what's the time frame? It's so over the course of the day. I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages, I will
Or
look,
the statements or the evidence that you're trying to put in under this doctrine?
his niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting the relationship.
Okay.
And there would be nothing different from the last trial, other than the fact that we are not going to pursue the Aruba.
and they've had a chance to sit there and talk to the niece about all this stuff, and because she really didn't say too much about that, Brennan, in the first trial, sir.
Information. So it is actually a narrower time window than before.
Okay. All right. I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have
Text
the
messages.
full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Ms. Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points that need
Correct.
to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a what was considered and what was testified to in the first trial is a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. Couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Read, that may be a different analysis. Certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Read with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence, that was imparted, or those specific conversations were imparted to Miss Read. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Read at both C.F. McCarthy that night, as well as at the waterfall that night, show the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. Mm-hmm. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And it's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Read had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Read would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes
he was only angry that he was ignoring her
out
texts.
one evening, having drinks with friends, in a good mood, and happy with one
When
another.
you're hanging out with somebody, yeah, I'd be upset too.
We
if
cite a
they
case
weren't-
called McGaw,
We had
McGaw,
plans,
M-A-G,
you know,
R-A-W. And just for the record,
left
I'll
for the
state the site. I
weekend
think it's at 426
during this
Mass 589.
snowstorm, and you dogged me
And the
out.
McGraw
Yeah, I'm going to be
court
mad.
provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, "A murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it." The best evidence that the second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Read never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Read's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary
She'll let her
standards that are
know.
required. The Commonwealth
She did the
cannot meet
last
those
time.
standards and
She'll
pursuant
let
to
her.
McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth.
Oh
is
my
that
God,
They
shut
were
up.
lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by
After
Ms. Voss
she
on
left.
June 20th, 2023, about that night, or the day before. She says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep. Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. This is minutes before we allege the collision happened.
That's
And
for
so,
Jen McCabe,
in the
though.
interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive. Without reading them, because it's unnecessary, there is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
Your Honor, if I could just correct the record very quickly.
Sure.
If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the transcript. Every time he stands up, he says, I wasn't there. I read the transcript. We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry. I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows and Jim McCabe and Kerry Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being about some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Read's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever. No evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Read had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? Yeah, I did. You know, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment.
Like nothing
Getting
was
along
wrong.
fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22, not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard, totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right, so we're going break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this.
Yes.
Hold on. Both sides. Both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods,
Finally,
all of
Judge.
that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2 o'clock.
Your Honor, if I could say one more thing. As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
She is so biased. I can't stand it. Hold on, we're gonna move right past this. Jeez Louise. This is crazy. I've never seen a trial like this before. It's absolutely wild to me. Oh, go back. There we go. I believe that's where they start. How much more left do they got going?
Here, I don't want to time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side 2 minutes. We'll see how we do with that. And we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a juror questionnaire?
I know you asked us to. We have not.
All right, so today's our trial conference where I'm supposed to have all of this, right? Can you do it before you finish? Well, let's see where we get with the motions and we'll see about that.
Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
It's taking 30 seconds. I want the court to be super clear about this one. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear.
I understand what your point is in making
there
it.
was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
All right.
That's clear. Thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question. Yes.
All right. So I'll hear you on your motion, Mr. Brennan, and then a 2-minute response. Jimmy, keep track, please.
Yeah.
Go ahead.
Thank you. During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown.
They don't need to tell you.
From
all they need to know and tell you is somebody else did it, not Karen Read. That's
third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so
they don't have to know. It's
position
not
that
their
they did not
job. It's
know
your
who the third-party
job.
culprit was. In our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence
Somebody in
they
34
suggest
at
supports
Fairview,
third-party culprit.
dude.
I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the
So
defendant.
I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See.
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Mr. Yannetti. Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium?
Yes.
Thank you.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate Software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. It's secondly under 1006. The appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right, I appreciate your brevity too. Thank you.
You're welcome.
Mr. Brennan?
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are open. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can.
Okay, thank you very much. I'll get a decision quickly to you now. Does the defense
She'll let
intend
it
to
out.
bring up any bad character or misconduct of John O'Keefe or any witness?
Yes. Yes.
No, bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until it would otherwise be prior act evidence, but they think it needs an exception under the.
Open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not during the opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before trial, a week before the evidence starts.
Thank you.
Okay, that's paper 587, Mr. Clerk.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson. And it also includes a request to exempt from sequestration.
Your Honor, with regard to this motion, we have on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product. So any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the appropriate time.
Okay.
Thank you.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should mention that.
Okay.
Thank you.
All right. So they're both exempt from sequestration. Okay. So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it back on March 10th, right? With Michael
is.
Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant to the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of an advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there.
It should be admissible because it
All right,
has
so you just
to
received
refer
it. When
to
do you
her case and
anticipate
her case alone.
being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
We had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their positions? Maybe they found him acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I would need, I think, till the end of next week.
Is that at the same timetable you would have whoever's arguing for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some,
Right.
even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's
So-
just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right. Is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay.
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quickly as I can. I have a lot of
Okay.
obligations over the next week. I'll try to facilitate it. I just don't know.
all right, without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So, All right. So, Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed and or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right. And then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it and we can do it. So I guess we won't meet on the 31st on this.
Thank you, Your Honor. I appreciate that.
All right. So on the 1st, you'll tell me how much time you need.
Well, you still haven't. The third party culprit you need
All
to
right,
hear.
so Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you a 2-minute, when I cut you off after 2 minutes on third party culprit. And then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're-
last time I said I wasn't excluding it, you just couldn't open on it. Right? So that's where I'm at this point, and I'll hear a different side. So
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but you know, I guess I'll hear you on your motion on that. Then.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular
There's
individual
3 people.
and John O'Keefe.
Three
I start from the
people.
premise that every
Ron
single
Albert,
witness
Brian
testified
Albert, Brian
testified that John
Higgins,
O'Keefe never entered
and
the home at 34
what's his
Fairview.
bucket for
Every
covering
witness,
it
there is
up?
no substantive
And Jen
evidence
is an
that John
accessory.
O'Keefe ever entered that home.
How
So
do you
open
not
up an
know
invitation for
who
defense
the
to
third
start to
party
present
is?
Evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness.
Jen
So I haven't
and
heard any basis or any proffer by the
Proctor were
defense that would
accessories.
substantiate any
But
particular
there are
witness as
3
a third party
people.
culprit.
Plus
Now,
a
there are some
dog.
cases that say you
Dude.
don't have to actually identify the witness. Those are
They
particular
don't have
circumstances where
to.
there's still substantial
It's
evidence
not
that
their
an unknown
job.
person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at sidebar fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third party culprit is and what do they want to introduce? Do they have a witness? Do they have evidence? Do they have any records? Simply assailing people's character.
They have a
randomly
police
is
officer that just
improper,
lost
it's
his
unfair,
job because of
and
this
then
shit.
it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court
No,
should
it
order the
doesn't
defense to
confuse the
articulate
jury.
who they claim their third-party culprit is, and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the
They
court,
don't
whether
have
we
to
think
do
it
their
is
job, Brennan.
appropriate or whether we think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court, in the course of seeing third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence. They shouldn't have, they could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding,
Yeah,
there
you
would
do
be no
need to
guardrails, there'd be
speak
no
on it,
parameters, and it would be chaos.
because he's got it.
All right. So, Ms. Giannetti, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowdoin, or is it simply somebody else did it and we don't know who?
It's the second alternative. In other words.
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's third-party as it goes to Bowdoin, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can you make
It's
an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
3, yes.
Okay, so can you tell me the 3 that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over here?
He's already said this before. Why are you, why, Judge, why? Sidebar. Sidebar. I like their accents. Sidebar. Come to sidebar. Rock the Casbah. Anyways, I love talking to myself. That's the only thing I hate about doing this is I feel like I'm talking to myself, even though it says I have people in here. But when people don't type and stuff, it's hard for me. But I'm gonna get over that. I'm an introvert. Unless it's something passionate that I care about. And this is something I'm passionate about.
The defense has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand
Like
up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed. And
Oh, God. Oh, God. Here we go.
So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events,
Hey,
that I
Daniel.
provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes. Thank
All right.
Thank you, Your Honor.
Thank you. So 607, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th. All right. The Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I hear you on that, Mr. Brennan. I figured this is probably lengthier than the others.
That's sorry, Your Honor.
I figured this might be more than 2 minutes, might be lengthier than the others.
Fibromyalgia pills.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case.
But you got Jen McCabe and all them coming in about their personal opinions to this case. Come on.
This investigation was appropriate or not, or whether
It's okay for you, but not for them, huh?
Different.
All right.
Inevitably, whether he
Gotcha.
thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to stop by telling me what you expect him to testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, which should look like, what a proper investigation should
How
look
is he
like.
an expert on that? How is that a field and how is he an expert on it?
I'll go
Is
through
it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigation. He was a lead case for many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure. Sure.
All
I've
right.
already shared it with the Commonwealth, but I'm happy to share it with the court, his expertise and why the law in the Commonwealth allows, in 702 allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to, or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
Witness
when
interview.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence.
That would be a good witness. Good witness.
Certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked them up, looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, The expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word,
That
for
would be a
example,
good
physicians,
witness.
physicists, and architects, but also the large group, sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the Rules of Evidence 702, the Federal Rules of Evidence 702, clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education beyond that of an average layperson, in particular, in a field without, or in a particular field without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formerly coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases, the 2015.
Time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report.
Okay, so that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like.
So I wanted to know specifically what you intend to have him testify on, but if it's in his report.
It's in his, it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative.
So I guess
technique.
that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert.
I hope she lets him in. Let him in.
All right, can you get me that report before you leave? Do you have it extra?
I think,
All right.
I think we probably have an extra copy of it, yes.
Mr. Brennan, did you want to respond?
I do. Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police.
Hello?
This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked at the state and federal court, that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know. That
Who
this
says
witness
it's a
ever
Bowden?
qualified
They didn't
to
say
be
it was a
Bowden-type
Bowden
witness in
defense.
any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate.
I think you should let it in,
This
Judge.
is argument by counsel.
Your Honor, very briefly, I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
You wouldn't
hang
be
on.
objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it. Do it. I'd love that. I'd love a shot at that.
Okay, so I said, let's take personal.
That's not an invective. That's not a personal shot, Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowden defense,
They don't have to,
adequacy of the
but they are
investigation. And there's no
entitled to
question
it.
that a proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that, all right, that expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So I'd like a case site.
There are certainly cases outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to our finding, there isn't one directly on point, but there are plenty. There's a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout
So
the country.
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine. Did I miss anything? All right. Well, I need that. Oh,
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't. We have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a 1-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional 1-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions.
Right.
If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment. It makes sense to me.
Oh, I'm sorry, Your Honor. I was looking for outside cases. No, there's no objection.
All right. So I need the joint questionnaire, and it can be that 3rd page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Well, obviously, it'd be a day after Monday then, right?
Yes, Mr. Unit, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing on. The
Okay.
defense just received notice this morning, so we're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
They're coming back Monday.
Okay.
Dum dum dum. So they're coming back Monday. They're coming back Monday. Are they coming back Monday? Well, no, that was eventful. It's always eventful watching this. So I'm guessing they're coming back Monday. I'm not sure. Anyways, I don't think that they come back. Let's see. 2:23. They come back Monday, but yeah. So I guess that's that. Hold on, let me put me up here. Thank you everybody that joined me and watched me freak out. This case is weird to say the least. So yeah, thanks everybody for watching with me. Please like, share, subscribe, comment, all that great stuff. I'm an introvert that loves the law. I love the law. So, and I know I'm a little shaky at this. I'm not a professional. You know, I'm just a person that loves the law. I wanted to be a lawyer, but yeah, I can't lie. Anyways, all right. I appreciate everybody joining me. Remember to tell those that you love and care about them that you love and care about them. And because tomorrow's not promised. And, you know, watch your surroundings, you know, be very, very mindful of who you have around you because you never want to end up like many defendants in the United States. So, yeah. All right. Stay blessed, everybody. Thank you. Bye.